Good afternoon. This is the May session for the Court of Criminal Appeals in Nashville. The panel this afternoon is Judge Robert Montgomery, Judge Tim Easter, and I'm Norma McGee Ogle. Each side will have 20 minutes for your arguments. If you would like to save some time for rebuttal, please let me know before you begin. We're ready for to call the first case.
The State of Tennessee versus Joseph Anthony Santillan.
Ms. Coleman, you're recognized.
Thank you, Your Honor, and I would like to save 5 minutes for rebuttal, please. So in this case, we are asking for a new trial, which was denied in trial court. We have 5 arguments in which we would argue today for a new trial. The first is that the trial court erred in not allowing Ms. Cruz, who is a crucial testimony in this case, to allow her past criminal history for the past 10 years to come into court for purposes of discrediting her. We believe that the standard of review is that applies is State versus DuBose because the court did not abide by the rules set forth in the criminal court of procedure. We believe that State versus Langford allows for an independent determination by the reviewing court because procedural guidelines were not followed. Thus, this honorable court should independently review the court's decision to not allow Ms. Cruz's full 10-year criminal history to come in. We would ask that it should be overturned because the trial court did allow in a crime from the defendant's history for which the state did not give notice. That was the forgery conviction. The defense counsel was only given notice of a single crime, not that forgery crime. So that is definitely burdensome and prejudicial to my client. Additionally, it should be case should be overturned because it did not allow Ms. Cruz's full 10-year history, including her juvenile record, because I think she was only about 22 at the time of the trial, to come in as would be normally allowed to undermine her truthfulness. When determining whether a civilian witness, whether or not, the first step is to determine whether and which Tennessee criminal rules of evidence would apply, whether it would be 403 or 609. To determine that, the reason that there's a question here is because Ms. Cruz was a co-defendant in the case, but she was severed off. If determined that she is still a co-defendant because she's still technically associated with the case, the crimes that that we would ask to be allowed in would not have been prejudicial to the jury for which she was testifying because she was not on trial on that day. They were not judging and deciding her lifetime fate on that day. So we would argue that allowing these crimes would not have been prejudicial to her, but would have allowed for my client to be given a full and fair hearing. The state does argue that this issue was waived because my client's trial counsel did not stand up and object and argue that this criminal history should be let in. It was only Mr. Nunez's, who is Mr. Santillan's co-defendant at the trial, only his counsel stood up and argued. We would argue that that is not the case, that they were waived. In a co-defendant case, there is precedent of co-defendants standing on motions and objections made by their co-defendant's counsel. This procedural issue is very common. It allows the court to continue the trial with judicial economy, and the jury is not subject to repetitive testimony and questioning. State provides no case law or court rules that state each defendant in a co-defendant case must raise issues individually in order to ensure that that issue is not waived for appeal. Thus, there is no precedent for their argument. In fact, if this honorable court chooses to abide by the state's argument, they will be going against over 200 years of trial practice precedent, and will be changing the way co-defendant trials take place on a day-to-day basis. Trials will be elongated, juries will become confused and annoyed with the repetitive nature of trials, and co-defendants' ability to receive a fair and unbiased verdict will be a result. So we ask this honorable court to disregard the state's argument of waiver and allow the issues to be determined on its merit. And we would ask that this case, again, be overturned because the trial court did not abide by the rules in allowing for Ms. Cruz's full 10-year history to be used against her and for her to be attacked on her credibility and her truthfulness with those juvenile and adult records that should have been allowed in. The second area that we would ask your honors to overturn this trial is that Mrs. Cruz, trial counsel was not allowed to cross Mrs. Cruz on the leniency in sentencing she was expecting due to her testimony. As stated before, she was a co-defendant and was charged with the exact same crimes that my client was charged with. The standard of review in this particular situation is theoretically the abuse of discretion. But it is important to note that a defendant has a constitutional right to confront a witness without restriction. In Rice versus State, this court overturned trial court decisions to not allow defense counsel to ask about leniency of sentencing of a co-defendant witness. The witness was given a community corrections sentence instead of prison time. In Salius, trial court decision was also overturned because counsel was not allowed to ask about a bond reduction that was allowed for a co-defendant due to their agreement for testimony against the defendant against Mr. Salius. Here, similarly, Cruz instinctively should have known she would not get a better deal if she would get a better deal if she testified on this case. And in fact, she did. She was given 15 years and not life in prison. Yet, yes, she had not pled, and the Davidson County DA's policy is not to plea or give a deal or a solidified deal ahead of testimony. But I would argue that this policy that the Davidson County District Attorney has is a policy set to circumvent this honorable court's decision in Rice and Salis. By allowing the trial court's decision to stand, this honorable court will be allowing the district attorneys to continue to circumvent the court's will. The state again states this issue was waived because Mr. Santillan himself or his trial counsel didn't bring it up in trial, only his co-defendant did. But again, we would argue that there's over 200 years of precedent stating that this has not waived due to his co-defendant's counsel's arguments on this case. Our third argument is that the case should be overturned because the trial court erred in prohibiting evidence of the defendant's cooperation, prohibited evidence coming in of my client's cooperation with law enforcement. That cooperation specifically was that he himself turned himself in once he understood what was happening. The standard of review on this is that good character of the defendant should and always be allowed in, especially if the good character and reputation are of a time period close to the time of the alleged events. In that case, that states that standard of review is Fry versus State. The state argues that his good character evidence is not relevant to the case in chief. And in fact, it may not be. But when you're on trial for your life and for the freedom for your life, for the rest of your life, the relevance to the case in chief is not the issue. It is how you are perceived by the jury so that the jury can understand your true character in assessing whether or not you had the capabilities to commit such heinous acts. And that should be taken into account. The defendant is allowed to give evidence on character. This evidence does not need to be relevant to the case at hand, but it must be allowed in. In Strader versus State, the court found that a defendant on trial for his life, as was Mr. Santillan, is allowed to put on evidence of good character to strengthen the presumption of innocence. The character evidence that was not allowed in Strader if I remember correctly, was that he was a good person for the past 5 years and had not gotten into trouble. The court and had good relationships within the community. The court found that not allowing this evidence in was reversible error. Here, Mr. Santillan's evidence of his cooperation with the police and with turning himself in was not allowed. I would argue that a defendant's cooperation with the police and turning himself in on such serious charges as felony murder and first-degree murder is a much more important and much more impactful evidence of good character than the facts that were not allowed in Strader, and for which the Strader court overturned the conviction. Thus, we ask this honorable court to follow Strader's precedent and to overturn this conviction due to the court's error in not allowing in that evidence of good conduct and good character evidence. Fourth, we would ask that this court allow this court overturn the trial due to the trial court's error in allowing in prejudicial evidence. The standard of this review is, we would argue, is abuse of discretion. It is obvious through the testimony that the victim in this case was murdered through gun violence. All the photographs must be, and State v. Van states that all photographs in a case such as this must be relevant to the issue the jury must decide. Here, there is evidence more relevant than the pictures the state could have used to prove its case against Mr. Santillan's co-defendant, Mr. Nunez. This court should follow Banks and Powell in determining that in a clear-cut case of felony homicide, there is no occasion to prove the character and extent of the wounds the victim and the use of photographs are inherently inflammatory towards the jury and prejudicial towards the defendant. In this case, the photographs only showed the wounds. They did not further prove the method of death. Thus, they were more prejudicial than they were probative. And Mr. Santillan was harmed by this prejudicial nature. The gruesome nature of the pictures prejudiced the jury against him and all but excluded any chance that Mr. Santillan could be convicted of a lesser crime. And the case and the verdict should be overturned thus. The state argues that this issue was waived. This issue was brought up in the motion for new trial and was ruled on by the trial court. So we would argue that this issue was in fact not waived. Finally, we would argue that this case should be overturned due to insufficiency of the evidence. Nothing in the record stated that Mr. Santillan had or used a gun at the time of the incident. To be convicted of first-degree murder, you must have intent. How can you have intent if you've never held the murder weapon?
Was this conviction based on criminal responsibility?
It is a completely criminal responsibility conviction, yes, Your Honor. Which I would like to get up on a soapbox for that, but I won't today. Based on this particular case, to tell you the truth. With felony murder, one must have intent to commit a felony in which during the act of murder occurs. There's no evidence in the record that Mr. Santillan had any intent to rob the specific victim in this case. In the idea to stop the car was complete, in Ms. Cruz's testimony, was completely that of Mr. Nunez, and there was no testimony in the record that shows Mr. Santillan agreed with this decision. There is no testimony or evidence that proved beyond a reasonable doubt that Mr. Santillan should be held criminally responsible for the actions of Mr. Nunez. And there is no evidence that Mr. Santillan shared the same criminal intent to promote. Sorry, I'm reading to share the same criminal intent of Mr. Nunez or its promotion of the crime that he was taking against the victim. So for those reasons, we would ask that you overturn the trial court, the jury's decision, and allow Mr. Santillan to have a fair and new trial. If there aren't any questions.
Thank you. That's perfect timing. You have your 5 minutes for a rebuttal.
Thank you.
General Coleman.
Good afternoon, Your Honors, and may it please the court, Ronald Coleman on behalf of the state. I will address each of the issues sort of in the same order that the defendant has presented them today. So the first two issues that the defendant raised deal with an accomplice whose name was Cruz, who was the driver in this situation. The first issue that the defendant raises is that the trial court erred in limiting the questioning of Cruz regarding her criminal history. First and foremost, however, this issue has been waived by the defendant. I know the defendant here today argues that they are allowed to stand on a co-defendant's objections, but the state would submit that that at least has to be somewhere in the record. And I have combed through the record. I've seen situations on appeal before where there are multiple defendants, and one counsel says, trial counsel for this defendant will be making all of the objections, and please construe those as objections from all of the defendants. That is not what happened here, at least from what I can see in the record. There was never any indication to the trial court that that was what happened. And so the defendant had to make his own objections, or at least alert the court that he was raising those same objections. Here, because he did not raise those objections, he did not file a pretrial motion asking to impeach Cruz with certain criminal history. He did not question her at a jury out hearing that took place, and he did not cross-examine her on any prior criminal history. The issue has been waived. And because he has not requested plain error review, this court should decline to conduct it. But even if we were to look over this waiver and go straight to the merits, the fact of the matter here is that there is no proof in the record whatsoever of any additional prior bad acts or criminal history or criminal convictions even that would have been admissible. And so the trial court could not have abused its discretion when it did not have anything to rule on. And so it's important to look at what exactly happened at this jury out hearing. I think that is relevant. And so what happened was counsel for Nunez asked the court for a jury out hearing to inquire of Cruz on her criminal history. And his first two questions were along the lines of, can you tell me in the past year, have you robbed any cars? And she said, yes, I've done that. And then he said, can you tell me in the past year if you've robbed any stores? And she said, yes, I've done that. And he said, can you tell me in the past year if you've robbed any houses? And at that point, the trial court asked counsel, where's your factual basis? Rule 609 requires that you have, 609 and 608 require that you have some factual basis in asking about this criminal history. What is this specific act that you want to get in? And the counsel didn't really have a valid answer. And so the trial court said, I think you're fishing. Tell me exactly what you want to ask Cruz to impeach her based on prior bad acts or prior criminal history. And the counsel for Nunez even said, I just want to ask her about these two specific questions. And the trial court allowed those questions. So it's important to note that nothing in the record shows any prior specific acts that were not asked, doesn't show any convictions that were not asked. And again, just to reiterate, the defendant never raised this. So it's waived, but even if it's not waived, there was nothing before the trial court and there's nothing before this court to establish that something should have come in. And for that reason, the defendant is not entitled to relief regarding the questioning of Cruz on her purported criminal history. Moving on to the next issue, which also deals with examining Cruz, I think it's important to pin down exactly what the issue before this court is. The issue raised on appeal specifically is that the trial court erred in limiting the cross-examination of Cruz regarding her hope for leniency. That is the issue before the court, and the reason why that must fail is because there was no such limitation. This court can examine the record and see that the defendant was able to cross-examine Cruz about her hope for leniency, about the fact that there was no deal in place, that there was no agreement, she had not pleaded guilty yet. And that occurred without any interruption from the trial court and without any objection from the state. So to the issue that was raised on appeal, the proof shows that the defendant was not limited in questioning Cruz regarding her hope of leniency. And again, that's for that reason alone, it must fail. On appeal, the defendant has raised a confrontation clause issue and argued a constitutional right to examine the defendant or to examine Cruz on her hope for leniency. But again, that issue was raised for the first time on appeal, and so it has been waived. And even if it hadn't been waived, again, the defendant got to ask Cruz about her hope for leniency. The fact that there was not a deal in place does not mean that they were prohibited from asking about that. And then lastly, again, to pin down this issue, it's about the limitation in cross-examination. And it sort of has morphed into a claim that Davidson County has some sort of nefarious policy of what's going on. And the fact is that is not the issue before this court. But even if it were, it was expressly raised by Nunez. And this court can take judicial notice of its opinion in Nunez, where it found that simply is not a valid claim. And there really is no relief warranted based on the fact that prosecutors are exercising their discretion and waiting to see what accomplices say before they extend any offers of leniency. So again, the defendant is not entitled to relief on either of her issues regarding the accomplice Cruz. Turning next to the evidentiary claim, the defendant argues that the trial court abused its discretion in excluding information that he turned himself in. And I want to point out something that was said today is that the defendant claims that this does not need to be relevant to the case. And Rule 401 speaks directly counter to that. The trial court here determined that evidence was not relevant, and that was a proper determination. In fact, it was almost beneficial to the defendant because turning himself in without any proof of the police wanting a warrant or that the police were seeking him could have shown to the jury evidence of consciousness of guilt. And so certainly the trial court did not abuse its discretion in determining that this evidence was not relevant to the case. It did not go towards whether or not the defendant had helped commit this crime. And even to the extent that it was such an error, it was clearly harmless beyond a reasonable doubt. And so if there are no further questions on that, I'll turn to the final evidentiary claim, which is that the trial court abused its discretion in two different evidentiary rulings. First, the claim that the trial court erred in allowing the publication of the victim's T-shirt along with the bullet holes and the blood that accompanied that. And I want to point out to this court that T-shirt had been admitted into evidence without objection. And so really we're looking at the publication of an already admitted exhibit at that point. The jury at any point during their deliberations could have asked to see it. And this court has previously held that publication of an already admitted exhibit simply cannot be prejudicial. And for that reason, the court's ruling on the shirt, on the victim's shirt, was not an abuse of discretion. Turning to the autopsy photographs, again, this issue has been waived. And it's not waived because it wasn't raised in the court below. It's waived because this court does not have the photographs that have been challenged in the record on appeal. The defendant has claimed that the gruesome nature of these photos, fully shows that they were prejudicial in nature. But it is impossible for this court to make such an analysis because we do not have the photographs in the record on appeal. And without that, we must presume that the court's findings were correct. But absent this waiver, we can look at the record and see that the court clearly exercised its discretion and clearly consciously considered each photograph. The record establishes at least that 8 to 10 photographs were presented to the trial court. The state attempted to get 8 to 10 photographs into evidence through the medical examiner, and that the trial court looked at these and at a minimum and only allowed 4 photographs into evidence and explicitly said, I'm going to exclude evidence of these photographs that are of the heart and the lung. And so from that, it is abundantly clear that the trial court was exercising its discretion and carefully considering the balance between the probative value of these photographs versus their prejudicial nature and potential gruesomeness. And from that alone, this court can find that it was a proper exercise of discretion to admit the challenged autopsy photographs. And if there are no further questions on that issue.
I have a question going back. Are you finished? Or I have a question about the admission as to character in the context of which he wanted to admit that. Was that to show I'm just a good guy, or that I didn't have any intent to do this? I didn't hide. I didn't flee.
I'm glad you asked that question, Judge Ogle. I had meant to talk about Strader, and so I'm glad you brought me back to that. The record is slightly unclear as to exactly why it was brought in. There was no further discussion. It was the defense counsel asked the police officer, "Is it true that the defendant turned himself in?" The state objected on relevance grounds, and the court said, "Yeah, let's not get into that." There was no further expounding upon that. But the defendant here today and in their brief relies on the opinion in Strader versus State to argue that they were entitled to present that evidence. And the case here and Strader are inapposite. In Strader, the defendant testified and wanted to put on evidence of his good character to bolster his credibility with the jury. And our Supreme Court found that it was reversible error to exclude that because the defendant had put his credibility on at issue. He had gotten up and taken the stand, and so he should have been able to bolster that credibility. Here, the defendant did not testify. And so simply the reliance on Strader is misplaced because the evidence of his alleged good character of turning himself in, which could also easily have been seen as consciousness of guilt, was not going to be used in any way to bolster his credibility because he simply didn't testify. So at most, it was sort of to show maybe he was a good guy. And again, the court properly balanced the potential relevance of this versus the irrelevance and properly exercised its discretion. And even further, to the extent that it should have come in, that one singular modicum of proof would not have changed the outcome when, as I will get to now, the evidence overwhelmingly established the defendant's guilt. And so the last issue presented by the defendant is that the claim that the evidence was insufficient to support the verdicts. And there are really only two claims here. First is that he didn't have a gun, and that is simply irrelevant. To your point, Judge Ogle, this was a trial of criminal responsibility. The defendant isn't challenging criminal responsibility. And so from here, the proof overwhelmingly established that the defendant took part in this attempted robbery and that the co-defendant, Nunez, was the individual who shot and killed the victim here. And so the defendant could have been held criminally responsible for the murder, and he was, and so the verdict was sufficient for that. Turning to the only other claim or the only other challenge against the sufficiency of the evidence is that the defendant argues or asks, where was the intent to rob the victim? And the proof at trial established intent viewed in the light most favorable to the state. And so it's important to note that there is a prior scheme to commit a robbery. And that's important because as Cruz testified, she and several others were going to go rob an individual at some house. And prior to that, the defendant and several others were attempting to modify the defendant's car. Apparently, there was this distinctive blue light on the defendant's car somewhere, and they were trying to fix it so it wouldn't be so distinctive. They failed, but that's what they did before they went to go rob this other individual. Now, they ultimately backed out of that, and then they drove around for a while, and then the proof showed that the defendant and Nunez, once again, tried to modify this distinctive blue light. And from that, any rational trier of fact could determine that they were doing that specifically to try and go do another robbery, or do the first robbery since they backed out of the first one, I guess. But any rational trier of fact could establish that that was the intent. But the fact that they tried to modify this right before going downtown establishes an intent to commit a robbery soon thereafter. And for all those reasons, the state respectfully asks that you affirm the judgments of the trial court. Thank you.
Thank you, General. Ms. Coleman, you have your 5 minutes.
Okay, thank you, Your Honor. In response, on the first, again, we would state that just in general, we do not believe that there's precedence that in a co-defendant case that there must be an oral agreement that all motions and arguments are for both parties. When people are being tried together, we would argue that the precedent is that any motions, arguments, and objections are seen as for both parties, not just the singular defendant for whose counsel is making that specific objection. And so we would argue just in general that none of the issues in this case have been waived. Additionally, going back through, the general stated that there was no proof of abuse of discretion, but we would argue that there was. In the trial transcript, it is specifically stated that only the 12 months prior to the incident of Ms. Cruz's criminal history would be allowed in, nothing further than that. So that is an obvious ruling by a court against criminal procedural rules that shortens the amount of criminal history, regardless of whether there was criminal history. This trial court shortened the amount of time that could be allowed in as relevant and towards her truthfulness, and that is an abuse of discretion. And so we would argue that just that limitation shows that he was abusing his discretion in this way.
Is there anything to indicate there was prior criminal history other than the 1 year?
I do believe, and I'm sorry I couldn't find it, but I do believe someplace in the trial transcript there was talk of her juvenile history, which is admissible in criminal court in a truthfulness situation. So I do believe that there was a lengthy history in that case, and that was why it was brought up in the trial court and why it was shortened is because the state did not want her full 10 year of history to come in because there was a lengthy history. Secondly, on the motion to, I'm trying to read my handwriting, I'm so sorry. Sometimes it's scribble scrabble. On the motion to, on the leniency, we just would stand on our argument prior to this, and that a criminal defendant understands that they will get leniency if they testify in favor of the district attorney's office, and that that should be something that a criminal defendant can cross-examine someone on. Additionally, on the third case of the character witness, again, it does not have to be, the character evidence towards a defendant does not need to be relevant to the case in chief. It is to put the defendant, especially someone who is on trial for their life, is given the opportunity to put themselves in the best light as possible to the jury of their peers. It is their constitutional right to do so, and that was squashed by when the trial court sustained the DA's objection to the relevance of the questioning that Mr. Santillan's trial attorney was doing. And just to note, I was not his trial attorney, but I can only assume, in knowing his trial attorney and her breadth of a trial experience, that she was bringing this out, although it's speculation that she was bringing this out in order to provide some good character evidence on his behalf, which is his constitutional right. Additionally, we understand the T-shirt argument, but I believe that our argument really stems in the photographs, and just in the nature of the case, I don't believe this honorable court needs to see the photographs in order to follow the precedents, in that the photographs weren't necessary. It is obvious through the trial transcript that all of that the method in which the murder occurred, it was gun violence, and it was random gun violence. So therefore, knowing that, and knowing that this person was a victim of random gun violence in the streets of Nashville, the pictures of the actual wounds, in accordance with prior precedent, are not necessary. And finally, the idea that I would argue emphatically that the prior scheme to rob a known person, the person who they were going to rob prior to this event, was the aunt of one of the co-defendant of Miss Cruz, I believe. And so that prior scheme was not in any way relevant to this case. They had that prior scheme. They backed out of that prior scheme. So the criminal scheme ended at the point in which they decided not to rob anyone. And then they drove around for a while. And then this incident occurred. The idea that it was many hours before the scheme was created, many hours beforehand. It was in a completely different part of town. It was in Antioch and not downtown. And they were going to rob people that they knew. They were family members, not strangers. So the prior scheme that was brought into as evidence in this case was completely irrelevant and does not in any way show that Mr. Santillan, at the time that this incident occurred, was still in cohorts with what Mr. Nunez was planning. And so therefore the criminal responsibility argument that would bring Mr. Santillan into the same fold as Mr. Nunez, I think the burden was not actually met by the state, and that differentiation between the two schemes is very, very important, and does not show that he should be still held criminally responsible for Mr. Nunez's actions later in the evening.
Thank you. I believe you have used your 5 minutes. If you want to take another minute to wrap up.
So I guess, yes, please, if I could. And additionally, Mr. Coleman's statement that the prior scheme bleeds into this incident downtown, I think is broad and speculative in nature and should not be and that speculation can't be used by the court to determine whether or not Mr. Santillan should have been held criminally responsible for Mr. Nunez's actions. And we would ask that your honors please overturn this conviction and allow him to have a new trial. Thank you.
Thank you. That completes the arguments for this case, and we are ready for court to be recessed or adjourned, I guess.
This Honorable Court of Tennessee stands adjourned.
Thank you.
Thank you.